Hi, Keith, are you on? It's Amy.
Good afternoon. I'm seeing Amy, but I don't see anyone else. Is anyone else present?
Hello, this is Danielle.
Hi, Danielle. How are you doing?
Well, Keith is here too, and Meredith Gusky.
Oh, hi, Meredith. I don't see a single soul here, so if anyone wants to show their face, that would really help with the presentation. Hi, Danny. Let me just make, hey, thanks. Let me just make sure that I have capacity to connect with the presentation. I think I can, but we shall see. Are you seeing anything on your screen at this point, such as Amara Legal Center?
I see a block that says Amara Legal Center. Yes.
Great, excellent. One step in the right direction. While I'm getting settled in with this, I do have a pretest to put in the link where I can find that. Hold on.
I got it, Mary. Don't worry about the pretest.
Oh, you do? Oh, that's great.
I'm about to put it in the chat now.
Super. That's great. All right. Meredith, if I understand correctly, you are working on a case pro bono for Amara at this time? We have one more person. All right. Welcome, Kara. as you get settled in, I'm going to try to get started on the presentation. And first, thank you to everybody for showing up for the presentation, for having an interest in providing this really valuable service to our clients, and having the wherewithal to prepare the client and to get through all these steps together. So hopefully we can make it a little bit more painless, but it's never going to be completely painless, of which we will talk further more. Now, you are seeing a screen, if I'm not mistaken.
Your screen is not shared.
Okay, hold on. No, that's the wrong share. One sec. It's not shared now either. Okay. All right. I'm not even getting a full gallery view here.
Are you in your Zoom? Do you see a green button that says share?
No, all I actually, Danny, all I see right now is you, to tell you the truth. Okay, back to seeing more. Not that I don't like to see your face, but I see the green share button. What I could not do before was upload, so I'd have everything in one place in advance.
There we go. Now, I see
All
your-
right, now I just change it to slideshow.
That's perfect.
All right, very good. Well, listen, sorry for the delay, folks, but hopefully it will go more smoothly as we progress. And as before, thank you. This is really valuable work for our clients. It is really hard work. It should be easy work, but that's not the way the law is at this point. Just warning in advance. But what you have at the end is a client who has taken a big step towards a new kind of life for themselves. Now, what we want to do first is talk about who Amara Legal Center is and what we do. This is the only pro bono legal services center in DC that does work exclusively for survivors of human trafficking, specifically sex trafficking. And it's interesting what we're called on to do. We do everything for free. No client is charged here. If they are within our client population, their services are free, even if they have capacity to pay. Some people think that if they offer to pay, that their work will get a priority, but that's generous of them, but we don't do that. So that's just something to bear in mind when talking to clients. There are a number of things that survivors of trafficking are in need of to get their lives back on track. Sometimes they need protection against their traffickers. We offer civil protection orders. By the way, is my camera not working? Is that also happening here?
It looks like your camera is not on.
All right,
Oh,
here I am.
On now,
I've
it's
been here all along, but just something ghostly. Anyway, protection against traffickers can be had by way of a civil protection order. Family law matters come up, custody of children, things of that nature. Divorce especially might be a good idea. Some clients are asked by the prosecutorial authorities in the district to serve as witnesses. It's very important to give good counseling to clients in that circumstance. There are other things that clients want. They think about changing their names to affirm their new identity, and that's something we can help with. But this vacatur and expungement is a great way to start to clean the slate for clients. Problem is, it is a very tough slate to get in order. Now, This is just a little bit of information about DC and how much trafficking there actually is here. There are two factors that predominate in causing this to be something of a toxic mix for people being drawn into trafficking. One is a significant level of poverty in the District of Columbia still, unfortunately. And poverty forces people to do things of necessity that they wouldn't ordinarily do. So we are a completely judgment-free organization. We never, ever judge a client for having been trafficked or even for staying in the work of commercial sex after having been trafficked. What happens is people get into being trafficked. They have an arrest record as a result of their trafficking. It is often the survivor that gets arrested and the trafficker makes off scot-free. So if they have a significant criminal record, it's not going to be possible for them to re-enter mainstream society. And this is where the vacatur and expungement come in, because if they don't have the capacity to have a job, then returning to commercial sex seems to be a way to survive. So that is why we do not judge. The other component of DC, of course, is there's highly trafficked in the conventional sense of the word, a lot of traffic in this area, period. There's lots of hotels, there's lots of people visiting, all kinds of fun and games, you know, swamp creatures. I'm sorry, I shouldn't say that, but there are swamp creatures. Anyhow, so the other thing is that there's underreporting. We really don't know the extent of trafficking in the city. It is widely underreporting. There's always new and novel ways of entering into trafficking. During the pandemic, entrepreneurs were quite clever in terms of turning to online work and hosting pop-up parties where, you know, arrangements would be made. Guests would go to a certain house, and who would pop up but a trafficker to get people involved in the work. Now, the Trafficking Survivors Relief Amendment Act of 2018 is a very important bit of legislation by the DC Council because it allows for complete vacatur of convictions. Vacatur is such an old-fashioned word, but it is what it sounds like. It's to vacate, to make a conviction as if it never had happened before. Not as if there was a conviction and the record was sealed or put away somewhere. It is as if to get a reversal. So it is a great thing for the people who have been trafficked, because the DC Council was perceptive in realizing that people who are trafficking survivors are not criminals. They are victims of crime. They get swept into the net with police because of their activity on behalf of and under the influence of the trafficker. Footnote, by the way, not all traffickers fit into the stereotype that we know from TV and movies, etc. Not all traffickers are males that, you know, dominate women in sex work. A trafficker can be a personal friend of the person being trafficked and offer them drugs in exchange for their doing sexual favors for people. So be on the outlook for folks like that. Now, I would strongly recommend, there is a report of the DC Council that was issued at the time the law was enacted. I'd strongly recommend taking a look at that report. I can make it available or circulate it to everyone after this if you'd like. I am not one who is fond of reading legislative reports, but this one is significant. It talks all about the history and all about the spirit behind the law. There is not a heck of a lot of law in this area. So when you come to write your memorandum law to submit to the court, you will have that resource to turn to, and you'll be able to show the court, this is why we're doing what we're doing. So, very good document. These are the two types of motions. Motions to vacate and expunge, which is a sealing, and a motion just to expunge if there's been no conviction. Vacatur applies only to judgments, but other components of criminal matters can be sealed. These are the more formal forms of relief that I was just mentioning. These are good to have handy too when you're writing your memorandum of law. It's also handy to get a little checklist like this in front of your client. Just so as the client goes through his or her records, the client will know, oh, this is what I'm looking for. This is what I am going to be seeking. I'm a big proponent of checklists, Excel, everything else with respect to these records. And this is the brilliant diagram that McGuire Woods created for Amara. When you get to taking a look at your client's records, this is something that you can use to see whether the client can seek vacatur or expungement, or whether he or she cannot. It looks crazy. It is a little bit crazy. That's what you're in for. I make no representations to the contrary, but this works and you should have it handy and look at it at all times. There are some offenses that cannot be vacated. Obviously, the big ones are severe bodily harm to another human being, abuse of an elder, abuse of a child. Those people do not get the grace that the Trafficking Survivors Act affords. Be careful about motor vehicle offenses, okay? This often happens with people who have been trafficked, but there are some motor vehicle issues that come up that can't be the subject of vacatur. Now, in those circumstances and in other circumstances where there is an ineligible offense, that is where the 2018 Act really goes to work, because in cases where a person is not a trafficking survivor, there are limitations on what can be expunged if there's an ineligible offense in their history. And that one's going to take a deep dive and a careful examination with the client. If the client can be made to fit in with our population, then that's the road that should be taken. So these are all here as a checklist to be aware of. These events cannot be expunged or vacated. Okay, the movement, what you need to prove in preparing your submission to the court is you need to establish that the client is a victim of trafficking. You can do that through the client's own affidavit, okay? There's nothing wrong with that standing alone, but bear in mind that there is bias against our clients. So if you can get some form of collateral support for the client, whether it is a friend who took the client in after they exited the life, whether it's the community activity that the client engaged in after they ceased being trafficked, anything like that to establish the client's bona fides. The standard is a heightened civil standard. It's not a criminal law standard, but it's inching towards very close. And again, a well-drafted affidavit with which you will help your client is your first step in the right direction with establishing that evidence. So, as I just said, the court may grant the motion solely based on the affidavit or sworn testimony. Now, there are circumstances in which people who have been trafficked can get special status, particularly if there's immigration involved. It's important to check on this, see if anything like that is available. It's not an easy process from what I've heard. I've not had any direct experience with it, but definitely worth checking out. If there have been prior proceedings, if the witness has been if the client has been a witness against a trafficker, that would be good to know. You may not be able to get grand jury testimony, but you may be able to contact the DC AG or the U.S. Attorney's Office and say, you know, we do believe that this person was a witness in this investigation. Would you be willing to confirm that for us? See what comes up. You can get reports from a doctor, a therapist. I would be circumspect with respect to doing that in the case that there's bias against people who go to therapy after having been through a terrible ordeal for years. It still exists. Housing programs might be a more neutral resource. That said, I would not hesitate to ask a doctor or a therapist for some kind of confirmation that says nothing other than I believe this person to be a survivor of trafficking. Don't open the door. It's not okay. All right. Everything has to be all done. If the client comes in and they're still on probation here or in Maryland or Virginia, you're going to have to unfortunately tell them, you know, we may have to wait. Now, how much other jurisdictions are going to play in, I don't know, but I would check on that and make sure that DC won't take into consideration anything that's pending in another jurisdiction. This would include fines. For some reason, when you look at the records in DC Superior Court, just as the client is about to get discharged from the court system and sent on their way to their new life, having paid their debt to society, DC Superior Court can manage to tack on one last debt. You know, there's always a fee for $50 or something out there. So make sure the client has paid all those things, even though they seem silly and unfair. You don't want that cropping up after you've done all this hard work. Okay. Practice pointers. Yes, everything should be clearly marked as sealed. And if you use Case File Express, do that. Do it in any circumstance. If you're filing by paper, if you're filing by electronic mail, make certain that every document is marked filed under sealed. That is true even if the court has not yet granted your motion for sealing. Because you're not going to be able to take the documents back and say, oh, wait, let me fix these. So do it in advance. Also, the court clerks have called me and said, we need your motion to seal. I wrote it incorporated in the motion for vacatur. The court clerk wants a separate motion. And my feeling is, when possible, do what the court clerk wants. Do what the cat wants. The cat can expunge. Cats are good at that. Do as they request. It is a mess to, if you have 10 convictions and arrests, to be filing separate motions and memoranda and affidavits for each one, but that is how it is. What I would do in those circumstances is clearly mark the motion that's in question in any particular motion and put in a footnote related cases and put the docket roster in there. And the same would be true for your memorandum of law and for your affidavit. It's a lot of administrative work, but whatever helps keep things in good order, you probably should do it. There is a requirement in DC that you do have to have a memorandum of law for any relief that you're seeking. We do have some that have been drafted here. We're glad to share them. One thing that I want to focus on later is the issue of causation, because that is a very big deal, and I want our memorandum of law to reflect that. This suggestion to seek prosecutorial consent before filing the motion is a little bit more difficult to do than in the past. At one point, there were more cordial relations with the U.S. Attorney's Office here in DC. Unfortunately, a few people who were affiliated with Amara have left the U.S. Attorney's Office now. And secondly, the pandemic disrupted everything for the U.S. Attorney's Office here. So they're still digging out from under. They're not as receptive as they used to be. When you finally get through to their office, make a friend, let them know what you're seeking, ask them to consider whether they'd, waive opposition, tell them a little bit about your client's story with your client's consent, and see if you can establish a rapport. Chances are they will say no to consenting before you file for two reasons. One, they're busy. Second, it's to avoid an appearance of unfairness. Because there are so many types of cases that are presented to the U.S. Attorney's Office, the office doesn't want the reputation of having people go out and say, well, my neighbor, was arrested because his dog barked too loud and he had to go to trial. But, my other neighbor had, an issue with a housebreak and nothing happened. It all went away. So they just don't appear to be biased. That's another reason why they want a filing. There's really nothing to respond to, too, before you filed your motion. So be prepared for that. Government gets a great chunk of time. It gets 3 months to respond, which is going to seem like an eternity to your client. It's important during those 90 days to check in with your client, see how things are going, or even ping the AUSA that's assigned. Don't be obnoxious. Say, hey, how's everything going? Is there anything that you need from us? Be of service to them to the extent that you can do so in an adversarial context. The court may hold a hearing if for some reason the U.S. Attorney's Office opposes. So that's something that you will need to prepare your client for too at the outset. Just footnote to them. You may have to appear in court. Now, if your client has only appeared in court in the past as a defendant, that might be an issue, okay? You can explain that this is only criminal in name, that it's really a civil remedy, but still, it's generally speaking, not good memories for clients. So be aware that that might happen. Let the client know that. Okay, now causation is a big deal. And I bring this up because the relief that's accorded people who have been trafficked exists because there's a demonstration that any crime the person was charged with or convicted of was the direct result of having been trafficked. So you have to establish a causal link. Many clients understandably think, what? There was a trafficker in my life for 10 years. I did everything under his or her direction or control. Why do they want all this information? And that's understandable, perfectly understandable. They don't live in the world of the law. The other issue is that trauma bonding occurs. The cycle of violence, even if there's no physical violence, the cycle of violence that applies in domestic situations often applies to people who have been trafficked as well. There's a honeymoon phase. Everything is great. We're going to make a lot of money. I'll protect you. I'll give you housing and drugs. And then the person gets arrested and the trafficker is nowhere to be found. Okay. But the person is released with or without a conviction. The trafficker will appear on the scene and just be so sorry. Put the person back to work again. So be attuned to trauma bonding, be attuned to the issues that arise in interpersonal violence because they are much the same. There is a slight chance that you would be asked to put on an expert with respect to causation, okay? I do not think that Amara has a budget for this. What I do think you need to do is be prepared with the case law, be prepared with examples of trauma bonding. There are survivors out there who have spoken to the issue. There's a lot of literature. You can keep that in mind. There are at least 2 cases that I have at hand that discuss the acceptance of expert testimony with respect to trauma bonding. Now, that won't get you a budget to hire an expert, but it will get the court aware that, yes, this is really something. This is not, anything fictive or anything that's interposed just to be fuzzy with causation. So that is an important facet of things. And the last line here is a little bit corny, but it is important. This is for the client, no matter what happens in the court. One of our goals is to help the client to understand what has happened to the client and to have dignity in the telling of it. So when you draft the affidavit, which is the key document with respect to the filing, let the client first write out their life history, freehand, bring everything in, as if it were a victim witness statement, which it is in essence, but let the client go free with that, then start editing. They find out, okay, I was 12 years old when a neighbor's uncle, met up with me one day and he started talking and he said, I was good, et cetera, et cetera. And, after a while, matters proceeded, and the next thing the person knew, she was being trafficked for sex. So these are things to put into the affidavit, put them in there with dignity. There's no need for anything lurid. Dates are important though. When this happened, how old the person was, general year. The client may not remember exactly, but do the best that you can to create a chronology of what happened and when it happened, because next fun part will be having a look at the records that are on file at the DC Superior Court. It's a great starting place. They generally speaking have records that go very far back. You'll be able to pull everything up related to your client. The thing that you won't be able to pull up online is the critical stuff. There's always flags on the electronic database at DC Superior Court that says, here's the image, and then it says image not available. So if you really want to see the records, you do have to make a trip to court, but it might be worthwhile. The other thing that you will need to do is send out an inquiry to Federal Bureau of Investigation to see if they have any records, and find out what you can find out for them. The client, him or herself, needs to go to the Metropolitan Police Department and ask for all of his or her records. It costs about $7. I don't think that, except in extreme circumstances, Amara pays for that. But, it's something to talk about with the client. That is a client errand. Other things to think about are perhaps, has anything ever happened at a local precinct station house? Could there be any records there that never make it to MPD Central? This would be particularly of note if there was actually a domestic incident between a trafficker and the person who's been trafficked. Just see, does the station house have any record, phone call, 911 call, anything like that, that not only would establish a record, but would also confirm that the person has been trafficked. So something to bear in mind. Other security clearance information. I've never made a request for that, but it's not the worst thing in the world to think about. If there's been a clearance by DC Public Schools, which is unlikely if there's an arrest record, or if anybody's tried for a security clearance with the federal government, just check, make sure there's nothing there that you need to be aware of. Now, here's something that will take you back to your grandmother's day. Just because the client is getting their conviction vacated or their records sealed doesn't mean that in the future something might not crop up. So please, even though the records are no longer valid, have them keep a copy. You just never know. I know it's very convoluted. You would hope to be telling the client to tear up the documents or burn them, but no, something may come up. The other part of this is that sometimes there are ghost entries in records, particularly here in DC, where we're talking about really close relationship between the local government and the federal government. FBI records, they have obsoleted information concerning an arrest or concerning conviction that stays on the FBI's electronic records even after there's been orders of vacatur. It's an imperfect system, and therefore it's important to keep a copy of records on hand. Enough of that lecture. Okay. All right. Let's assume that everything goes well, that you establish a rapport with the U.S. Attorney's Office, that you submit a beautifully written motion, memorandum of law, and compelling affidavit on behalf of the client. And the court says, yes, it does appear to me, to the court, based on this evidence, that this person was a victim of human trafficking. Therefore, I am ordering today, and the court gives all the relief that you're seeking. Once that order goes into effect, everyone involved, FBI, DC MPD, courts, any parole officer, any probation officer, any fining entity, anything like that in government that would have word about these convictions or arrests needs to be notified. Then they have a full year to comply, which is ridiculous, but they do. They have to submit a testified to statement that they've searched all their records and taken care of this administratively, but it is time consuming, and that's something to talk about with the client on intake. The idea of using a private background check company is really to develop some cautions and some parentheses around what is being seen out there. I don't know who can pay for it. I don't know what the cost is, but it's something to think about and talk about with your client. Footnote to that is, if your client doesn't have money and you think your client would qualify to have a fee waiver, by all means, get the petition for waiver of fees in front of the court before you even come to the clerk's office. And when you file things, make sure you reference the name and the date that the order to waive fees was submitted and the date it was approved. Just make life easy on the courts. Now, chances are you won't lose, but if you do lose, it's an appealable order. I do not know of case law on the subject. I'm sorry to say. That doesn't mean there is none, but it's worth checking before you go in. Okay, this is a lot about sealing. And as I said earlier, if there is no eligibility under the Trafficking Survivors Act, it's a little bit more tricky, but you can still see what you can see. There may be things that can be taken care of. So pay close attention to what's here. It's imperfect relief, but it is some relief. Now, this is part of the relief that your client gets. This is called ban the box legislation when it came out. Clients don't have to worry once they've had vacatur or expungement if they're going to be turned down for a job, because it would be said that they were lying on their job application. They're not. So that's good to bear in mind. Another thing before we turn to interacting with survivors is, when you talk to your client first, see if they are going to be applying for a commercial license of any sort, because the law has been relaxed in that regard in DC. It's a relatively new law, but nobody can be denied a commercial license now unless there is a conviction, not an arrest, not a ticket, a conviction for a crime directly related to the license that's being sought. In other words, you know, if you're looking for a real estate license and it turns out that there's a conviction for bank fraud, it might be within DC's discretion to say, no, we don't think that you can have this license. On the other hand, you know, if you had a traffic accident and you want to cut hair, those are not related. So these are things to bear in mind when the client is going through these processes. And there's no reason for a client to wait to try to obtain a license just because the expungement process or vacatur process is going on. Second thing to bear in mind when you get to know your client well, when you have a sense of their reliability, the client may still be getting turned down for jobs or questions or provisionally offered jobs subject to someone talking about their criminal past. Then, if it's indicated to do so, we can provide comfort letters to employers. And generally speaking, those letters say, you know, Jane Doe is our client. She is pursuing remedies in court to have her criminal records expunged and sealed. Do not believe that those convictions were gotten. You don't have to go into detail. We don't believe that she should be denied employment or something to that effect because of those convictions. And you can talk about the client's new life if appropriate. I have sample letters that I'll be more than willing to share. So that is all the nuts and bolts of what needs to happen in the court. Now we need to talk about what needs to happen with the clients. As I said at the beginning, our clients, generally speaking, have not had pleasant histories with the court system and not had pleasant histories with attorneys. Try to take a minute to establish a rapport with the client. Try to make the client feel at ease. Acknowledge that prior experiences may not have been so good, and acknowledge that even if you have to ask tough questions, sometimes you are firmly on the client's side. So that seems like it would be common sense for people who are pressed for time, people who don't understand the client's background may overlook that. That's just not a step to skip. Be especially attuned to how you ask questions, because as you know, with domestic violence survivors, the universal question is, why did she stay? And if you ask in that tone to a client, you are not going to have a happy client. I mean, you will mar the relationship. You can ask something like, what was going on then? What kept you in that circumstance, so that you're not accusing, you're just gathering information. And that can yield some very important information. It may very well be that the person being trafficked was the victim of actual physical violence, or something else was going on, or perhaps a family member desperately needed money that the client could be paying over to them under the table. Don't try to become an expert in street language, because it will change before your very eyes. You do not have to be adept, and don't hesitate to ask the client, what does that phrase mean? I don't know what you're talking about. Try to use some of the language that a client uses. Clients talking about boyfriend, use boyfriend, even though you know that it's trafficker. That can be a matter for another day. Oftentimes people who have been trafficked don't realize it, okay? It's a slow awakening, so it's not yours to enlighten on an initial encounter. Try to get a sense of the client's overall life path, and be supportive of what they're doing now. Law words. I love this cartoon, and it's worth showing to a client if you want, and to let the client know that we don't always talk like human beings. You know, and lucky for us with respect to the trafficking statute, we do have something that sounds reasonably like regular language. Vacatur is fancy for vacate. Anybody could get that. All right, let's see. Okay, here are the clients that can come to Amara, which is just about anybody who has been trafficked without regard to any other qualification. Can serve DC now. We're hoping to evolve back into the other jurisdictions, but for now we operate primarily in DC. Yeah, and by the way, it doesn't matter how the client got here. You know, if a social worker referred the client, that's fine. If it just does not matter. And I want to, because I didn't go over it in the beginning, I want to point out that we try to offer holistic services. The client can come in with many needs, and sometimes probing is good. You don't have to, you know, be a bureaucrat, but say, how's your living circumstance? Yeah, are you okay? Safe where you are? What about food? Are you getting enough to eat? Are you getting support? Do you need help with applying for housing? And we have a number of people that can help us with those tasks, and we can make that information available to the client. And it's another way of showing caring and support for them. It's important. So this would bring us full circle. This is basically what Amara does. And what we don't do, try to find people for our clients if we can. So this is about the folks that are not Amara folks listening to the presentation. This is where you come in and where you are absolutely, completely valued because of the service you're providing for our clients, for us. With that said, that is the end of the formal part of the presentation. Here's the demand. Already we're demanding things of you. We will have a post-training survey. Please fill that out. That is not just because we like to gather information. The people who make Amara possible like to keep records of these things. They want to know that we're being effective. So if you could take a minute, that would be great. I'm going to look in the chat, see what's what. Okay. Yes. Thank you, Keith. That's exactly right. If anyone has a question, please ask now. Also, if you have a question and you don't feel like speaking in Zoom, I will provide my email to everybody, and you can call or email me there if you have a question that you don't want to present now. Okay. Questions are the best part, so don't hesitate to speak, please.
Mary, I just wanted to confirm something you said about filing under seal. There's the choice to, you can choose the sealed docket under Case File Express, but you've been told, and your understanding is that the best practice is to file a motion in addition. So motion to file under seal every time.
Well, that's kind of overkill to some, okay? Because of my encounters with the clerks, I think it's always helpful to have a separate document that says this is being filed under seal for them to rely on. Case File Express is sometimes helpful in these circumstances, but not always. I would be reluctant to omit sealing language in a document and rely on just the sealed docket terminology in Case File Express, because the court has to rule on whether sealing will be allowed or not. And I think you're probably aware there's rules, there's regulations, it's not automatic. So I'm very conservative in this respect. I try to leave nothing to chance, and I don't know if that answered your question. Does it?
Yes, thank you.
Okay. Make something up, ask a question. This is interesting work. I don't want to keep people longer than they wish to be here. If there's no questions, we can close out. But again, I would invite you to email me, telephone me if you have any questions. If you're interested in taking a client, definitely don't leave here without putting your hand up. If you do have a client from Amara now and you want assistance and supervision or any kind of consultation, I don't supervise, I consult. Because I like to walk through cases with people and share information as opposed to say, this is the way it is. These laws are not so well established that you can really truly say, this is the way it is. Do make good use of the McGuire Woods information. I will send to everyone, if they like it, a copy of the DC City Council's information, and we can take it from there. So thank you, everybody, for your patience, for sitting through what was, I think, a lot of information in less than an hour. So take care and be in touch.
Thank you.
Yeah, thank you, Mary.
Bye-bye.